The Fourth Amendment. The Fourth Amendment was included in the Bill of Rights to protect people from unreasonable and arbitrary intrusions of their privacy by the government. It sets out broad guidelines for police searches of persons and property, that searches can be conducted with a warrant and must be reasonable. But the courts have had to make significant interpretations of the Fourth Amendment over time. For instance, it's not always clear what a reasonable search is. The court must examine the facts and circumstances of each case to determine if the search was reasonable. In addition, the courts have found that some searches can be conducted without a warrant. So when can police stop a person and conduct a frisk? At the time of the Wardlow case was heard, past courts had determined that the police were allowed to conduct a warrantless stop and frisk search if the police officer saw the person acting suspiciously or had reason to believe the person was likely to be armed. A frisk is a brief search of a person with the aim of determining whether the person is armed. It's not a full search. Instead, it's a pat-down of the outer clothing. The rule allowed a stop and frisk in certain circumstances came from the Supreme Court's ruling in Terry v. Ohio, 1968. The court said, where a police officer observes unusual conduct which leads him reasonably to conclude in the light of his experience that criminal activity may be afoot, and that the person with whom he is dealing may be armed and presently dangerous, where, in the course of investigating this behavior, he identifies himself as a policeman and makes reasonable inquiries, he is entitled to the protection of himself and others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. The Terry decision requires that police have reasonable cause to conduct a stop and frisk. This is a lower standard of proof than probable cause. In determining whether there is a reasonable cause to stop a person, the police must be able to point to specific and articulable facts that support the inference of suspicion. In other words, the police cannot act on gut feelings. The consequence of this lower standard is the police can stop and frisk when they have a suspicion grounded in concrete facts that illegal activity may be taking place or about to take place. They do not have to see the illegal activity itself. In Sam Wardlow's case, the only indication that police had suspicious activity was Wardlow's flight from police. He was not engaged in other activity, nor did they have any indication he was carrying a gun. The question then became whether Wardlow's flight from police was reason enough to justify a stop and frisk. The state of Illinois claims in this case that fleeing from police officers is suspicious in and of itself. In this case, the court does not agree. Illinois also claims that a person's flight in combination with the surroundings of a high crime area are enough to make the fleeing person suspicious. On the other hand, Wardlow claims that there are many reasons a person might flee in the sight of police, making it impossible to determine suspicion or not. Ambiguities like these make search and seizure law very complex and force the courts to address the law on a case-by-case basis. This is why it's very important to examine carefully the circumstances of the Wardlow case. So why is suspicion attached to flight so important for Wardlow? Generally speaking, if a court finds a search to be unreasonable, then the evidence obtained during the search cannot be used against the defendant during trial. The principle by which illegally seized evidence is kept out of trial is called the exclusionary risk. When Sam Wardlow was preparing for trial, his attorney filed a pretrial motion to get the gun evidence suppressed. They claimed that the search was unreasonable because Wardlow was not doing anything suspicious and was not obviously engaged in a crime. Therefore, the gun should not be allowed as evidence to support the weapons charge. However, in this case, the trial court declared that his flight in a high crime area was suspicious and denied the motion to suppress the gun. During the trial, the evidence was enough to convince the jury to convict Wardlow. The evidence also became the reason for Wardlow's appeal to the Illinois Appellate Court.